Hey everyone, back for one more session of the law in a way that folks can understand it. So today I want to talk about situations where you've been arrested for DUI, they've confiscated your driver's license, it's been suspended either for refusing a breath test or for blowing over a .08. But you've had a previous alcohol-related suspension, so you're not eligible for the waiver review that we discussed in one of our other videos. So what does that mean? Well, within that first 10 days, just like if you'd never had a suspension before, you're going to get issued a 10-day driving permit, which is a business purposes license that lets you drive to maintain your livelihood, church, grocery store, kids, doctor's appointments, lawyer's appointments, work, that sort of stuff. During that 10-day period, though, it's important that within that 10 days, you submit a request for a formal review hearing to the division that deals with that, the Bureau of Administrative Review. Now, if you've hired us or another lawyer, they should be able to help you through this process. We do represent our clients in the formal review hearings. So you submit the application or your lawyer submits it. It's only one page. It's not tricky. Once you submit that, we'll get contacted or you'll get contacted by the Bureau of Administrative Review. They're going to collect a $25 hearing fee over the phone unless you've gone down in person to submit your application or your request for the hearing. So what is a formal review hearing? It's a trial at the DMV. There's no jury or anything like that. It's not proof beyond a reasonable doubt. Is it more likely than not that you were driving and that you refused the breath test or blew over a .08. There's other factors that are taken into consideration, whether or not things like the traffic stop were legal. Did the officer have reasonable suspicion to conduct a DUI investigation if, say, he just stopped you for speeding? We can also challenge whether or not the field sobrieties were properly requested, whether or not they were properly performed, was there probable cause for the arrest, and also making sure that the breath test was requested pursuant to Florida law, meaning that it wasn't requested before you were arrested, but afterwards. And if it's a refusal, whether or not they properly advised you of what we call the implied consent warnings. We have discussed the implied consent warnings in a different video. But essentially, that's just where the officer is supposed to tell you that if you refuse a 12-month revocation or suspension of your license for a first refusal, 18 months for a second refusal, and if you've previously refused, it could be a misdemeanor charge. So what the process is, we submit the application for that formal review hearing for you. We're going to get a copy of what's called the hearing packet. The hearing packet is going to contain not just the arrest report that you were given when you were released from jail, but also any offense reports, supplemental reports from other officers, and most importantly, the DUI evaluation form. It's different names, different agencies, but it's about a 3 or 4 page document with a checklist for, signs and observations of impairment, the field sobriety exercise checklist, that sort of stuff. So we're going to review all that and make sure there's no technical defenses to your suspension based upon the document review itself. If there is, we may not bring any witnesses to the hearing, but many times there is not a technical defense just right on the face of the document. So what we're going to do is we're going to go ahead and issue subpoenas for all the officers involved, including the breath technician, if there was a blow case. So we issue those subpoenas, get them served for the hearing date. If the arresting officer fails to show up when he's under subpoena, we should be able to get that suspension dismissed. Similarly, if you blew over a .08 and the breath test operator fails to show for your hearing when they're under subpoena, then in that situation, again, we should be able to get your driver's license restored. The hearing takes place typically over the phone these days. You do not need to be present for that. Most of our clients aren't. But during that time, you're going to have a 42-day driving permit. The hearings take about a month to get set from when we request it. So during that time, you'll be able to drive, and then they've got 7 business days from the end of the hearing to issue an order one way or the other, either invalidating the suspension or affirming the suspension. So anyways, it's not an incredibly difficult process, but it can be time-consuming, certainly beneficial and helpful to have a lawyer involved in all of that, especially when it comes to issuing subpoenas. So if you have any more questions or want to talk about that, please give us a call here at the office. Be more than happy to discuss it with you. All right, y'all have a good day. Thanks.